Well, good afternoon, everyone. We're going to get started. All right, it is my pleasure to welcome you to Case Western Reserve University School of Law and to introduce Mr. Kirk Nara. He is a graduate of Harvard Law School, where he was an articles editor on the Harvard Journal on Legislation. He's currently a partner at Wiley Rhine in Washington, D.C., and he specializes in privacy and information security litigation and counseling. He also specializes in a variety of healthcare, insurance fraud, and compliance issues. Mr. Nara is widely recognized as a top-tier, top-echelon privacy attorney, and I've been familiar with his work for many, many years. I've cited it, and it certainly has been a pleasure and an honor to meet him this afternoon. Mr. Nara's talk is entitled The Present and Future of Healthcare Privacy. We are going to hold questions until the end, but we will leave time for questions. And after the talk at 1 o'clock, Mr. Nara has graciously agreed to meet with students and to provide advice on healthcare jobs and careers and answer any questions you might have. That will be in room A64. So if you have class, go to class. But if you don't have class, please go across the hall and take advantage of this unique opportunity to talk one-on-one with a very prominent attorney from Washington, D.C. And now, Mr. Nara, we are looking forward to your talk.
Thank you very much. The part about going to class, I'm not necessarily going to agree with that, but that's okay. Very happy to be here this morning. I grew up about a mile from here. I was actually born across the street, so long time Clevelander. My folks are in the back. So here's what I'm going to try to do today. And I do a lot of talks on privacy issues around the country on different points, and I try to tailor them to the different audiences. And what I wanted to try to do today was really focus on privacy as a legal topic, first of all, and then talk about why these issues matter across the healthcare industry. And I'm going to make the argument over the course of today that the kinds of issues we're talking about, privacy rules, what you can and cannot do with data, is a driving force to the success, or at least the substance, of virtually everything we are trying to do in the healthcare industry today. You cannot design a healthcare program, a new initiative, a new project, a new kind of government benefit, anything like that, without having an idea of how you are going to handle and manage the privacy issues that are involved in dealing with this. And it's funny how important this has become over a very short period of time, because as I said, this is a very new legal issue. We were talking about at earlier this morning. I mean, when I was in law school, this stuff didn't exist. I mean, there was no law of healthcare privacy that anybody paid any attention to. It was something doctors knew they weren't supposed to, gossip about their patients, but it really wasn't a whole lot more than that. And so it's something that's built up really in the past few years. So I want to talk about where we are today, some of the big issues that come up today. I want to focus really on some of the challenges going forward in terms of how this law is going to evolve, and really try to emphasize places where these choices matter and get you hopefully thinking about how we're going to make these choices. I mean, I don't want to pretend at the end of this, particularly when we get to a series of questions I'm going to talk about at the end, I don't pretend to have some answers to these questions. I think there's a lot of choices, and what I'm seeing across the healthcare industry is that the people involved in policy in this area, people involved in the healthcare business, people involved in the legal field, people on the government side, aren't really focusing enough on asking the right questions. And we're ending up with programs that may or may not work because of how some of these privacy issues have been addressed. So that's my overall approach today, is that we will try to save some time for questions towards the end about what we're talking about. And again, I think that, again, as you think about this, and I want you to keep this in the back of your mind as we're walking through these different topics today, I think the challenges presented by privacy and data security, we're going to talk a little bit about security, in the data-driven world that we have today, really create one of the most significant challenges that we have across the healthcare world. Privacy and security are different, and they require different skills. One of the things we're going to be talking about hopefully later with some of the students, and one of the things that I think is really challenging for lawyers in this area, is that privacy we can understand. It's usually rules, it's what you can do, it's what you can't do. Data security, which is becoming just as important an issue across not only in the healthcare industry, but across all kinds of businesses, is a very different kind of legal skill. To be able to look at a law that says what you have to do to have security in your company, and as a lawyer to try to figure out what the IT people are doing in the basement of your company or your client's company, and being able to evaluate compliance from that is a real challenge that I think most lawyers are not today prepared to do. And so that's certainly an opening going forward for people thinking about these issues. But again, how we resolve these issues and how we address and define the privacy rules that we're dealing with, I think will go a long way towards evaluating how our success is coming out in this area. All right. As I said at the beginning, privacy is really a new legal issue. When I was in law school, privacy came, which isn't longer ago than I like to think about, but it's not that long ago. Privacy was maybe half of one class in constitutional law, where we talked about abortion rights, birth control, and whether you had to disclose your membership in the Communist Party. Those are not issues that occupy a lot of attention in corporate America. There were very few jobs for lawyers to deal with those kinds of issues. I mean, the ACLU had people, and that was pretty much the people who worked on those issues. I mean, you could come up with a handful of other examples, but no law firms were focusing on those issues. No practices within law firms were focusing on those issues. Virtually no companies cared at all about that as a matter of their company business. And so we've had that. We've had that in play for many, many years, but now what we've seen over the past, I would really say 15 years, is we've seen an explosion of laws and regulations across all kinds of industries and across the globe at this point, starting to address privacy issues. What role an individual has in controlling use of their data, what rights the individual has, what rights a company has, what kinds of obligations companies have to notify people about what they are doing with their data, ethical issues, what kinds of conclusions can be made about people based on their personal data. And so we're seeing an enormous growth in legal opportunities for lawyers, for law students, and challenges for companies in a growing range of industries to deal with these issues, manage with these issues, and understand how to run their business with all the data that we have. And one of the things that's happened just in the past few years as we've developed the sort of big data philosophy, big data principles, and the Internet of Things, is that the number of industries who have to care about these issues is growing astronomically. I mean, the idea that a car company had to worry about how they would manage the personal data that's being sent out of your automobile, or your refrigerator that's going to understand when you need to reorder mayonnaise, but that's generating personal data about the users of the refrigerator and the users of the temperature control in your house. And so just we're seeing this in such a broad range of issues, well beyond the core industries like healthcare, like financial services, where we've seen this a lot. And I think when you start to talk about the policy issues that come up in this area, it is my view, and again, this is somebody who works in this area, so I'm a little biased, but it is my view that the healthcare field actually raises the most complicated array of challenges and the most complicated set of overlapping and intersecting and sometimes opposing interests in this situation. And what I mean by that is that if you're going to regulate how a car company can use data that's generated by your car, how fast you're going, where you're going, those kinds of things, there's a limited number of interests there. When we start to talk about the healthcare field, you have to think about all the different affected audiences. We have patients, we have the industry, we have the government as provider of medical services, we have the taxpayers, we have the patient population at large, we have employers who pay for most of these healthcare services, we have the random population who might benefit from research developments. We have just a much broader array of interests that are affected by the choices that we make on privacy issues. And I think anyone thinking about any of the programs that we're dealing with in healthcare today has to be thinking about privacy law when they are designing their programs. Let me give you just a little bit of background to sort of set the baseline of what we're talking about when we're talking about healthcare privacy law in this country. The primary privacy law, mainly regulations more than law, is the Hipaa statute and the accompanying regulations. When I speak to professionals in this area, law students in this area, I say that the single most important thing I will tell you today is how to spell Hipaa. It has one P and two A's. I get at least once a week a marketing pitch from a firm who wants to sell me their HIPAA compliance services, and they spell it wrong. That is pretty much an automatic disqualifier. So there's actually a specific explanation for why people do that wrong, which is in 1999 and 2000 and 2001, when these laws and regulations were being written, I went to hundreds of conferences. What was given away at every single booth at every one of those conferences? Anybody know? A little stuffed squeeze toy in the shape of a hippopotamus, exactly. So that led everybody to spell it wrong. But now it's 15 years later and people really should know better. But that's the primary law. It is a federal, again, there was a law that comes out in 1996. There are regulations that come into effect starting in 2003, which set a federal baseline of privacy protections. I say baseline because we also have thousands of state laws in every possible direction all over the country that if they provide more stringent privacy protections, greater than the floor set by HIPAA, still have to go into effect. So we actually have lots of challenges with how to fit all these rules together. It is actually impossible to make sense of all of the different state laws that are out there. They were written, one law was written in 1947 because some state senator had some problem with this part of their healthcare record, and so they passed a law dealing with sexually transmitted disease. And then another state does it for podiatrists with how it's all over the map. If somebody wanted to get write a sort of PhD thesis in the law, you would actually compile every single law and regulation dealing with healthcare privacy, and it would be hundreds of thousands of pages long and virtually an impossible task. So we have all those laws. They are out there. They're part of the framework. We also have a variety of other federal laws that deal with healthcare information. The most important for purposes of evaluating policy has to do with federal substance abuse regulation laws, which were written in the 70s, basically designed to encourage people to have confidence if they went into a facility for substance abuse treatment. And it was a public policy goal to encourage people to go into substance abuse treatment facilities if they needed them. It has now become an enormous challenge across the healthcare industry to figure out how to deal with data about patients who are in those facilities in connection with everything else about their health, because we have this one federal rule that deals specifically with those issues, but was written for a different kind of purpose. So we're going to talk about that in a little bit. There's a ton of debate about how this enormous volume of laws affects the healthcare industry. I am personally of the view that I would get rid of almost all of them. I'd rather have one law that we could all understand. I wouldn't have a job, but the amount of time that companies in the healthcare industry spend trying to figure out what they should do, just how all these laws fit together is, I think, just wasted time and energy. You shouldn't, I'm going to give you an example in a few minutes of a situation that led to particular problems, but we spend a ton of time just figuring out what the rules are, and it really shouldn't be that kind of a possibility. So, again, we have the HIPAA statute as background. I don't know how many of you were paying attention to healthcare issues in 1996. In 1996, one of the big issues was portability of your health insurance coverage. If you had a pre-existing condition and you wanted to move from one job to another, it was very hard to do that because you would lose your health insurance. And so that became an artificial impediment to changing jobs. And so Congress said, we should fix that. And so they stepped in 1996 and solved our healthcare crisis. But what they did was they passed a law. You now see the implications of that. If any of you have changed jobs recently, you have the opportunity to continue your health insurance coverage. That's portability. That's the P in the middle of HIPAA. It's not privacy. Portability has nothing to do with privacy. So what Congress did, and those of you who have studied Congress at all understand that this is sort of an approach they have. They had one idea that everybody liked. It was actually passed unanimously. Can you imagine anything passing in our Congress today unanimously? But they passed this law unanimously. And then they said, all right, we've got one idea that everybody likes. Let's throw a bunch of other stuff on top of it. So they came up with things like there's a variety of healthcare fraud laws. I actually spent a lot of my early career dealing with fraud laws that came out of HIPAA. And for 10 years or so, when I thought of HIPAA, I thought of healthcare fraud laws. There was another concept that they came up with called administrative simplification, which of course, as you know, Congress is probably an oxymoron, but there are thousands of pages of regulations to do administrative simplification. But the idea was, we're starting to move into this electronic era in 1996. If we could come up with standardized computer formats for certain typical healthcare transactions, think a claim going from a doctor to the insurance company and the response to the claim going from the insurance company back to the doctor, if we could standardize those electronic formats, we would make things more efficient and we would save everyone money through efficiency. Interesting idea, not sure it's actually worked, but let's work with that. It was a good idea, they had that in mind. So they put into the law administrative simplification starting with standard transactions. Then Congress said basically, well, you know what? We've got this new thing coming up in 1996 that we don't really understand called the internet. Senator Gore invented it, of course, we know at the time, but nobody really understood it, and they said, maybe we should be worried about what's going to happen with all this electronic stuff. So maybe we should come up with some security ideas. And while we're at it, let's figure out what to do about privacy. So if you actually read the HIPAA statute, it says the word security and it says the word privacy, but it basically doesn't say much of anything else. And so there are virtually no substantive principles that you can look at the HIPAA statute and come up with anything about privacy. Congress, in fact, recognized what they had done, and they gave themselves 3 years to come up with a law on healthcare privacy. Now, again, everyone in the audience knows something about Congress. Can you guess what happened after 3 years? Nothing. Not one single bill got out of a committee to become privacy. So what they had done was they forced HHS to write a regulation if they couldn't act themselves, but that left to HHS basically coming up from scratch with what the privacy rules should be. So I go into that background because when you have these rules, they were derived from a statute that had nothing whatsoever to do with privacy and security. So the implications of that mainly deal with how the rules work. There's something called a covered entity in the rules. That basically means healthcare providers, doctors, hospitals, pharmacies, and health insurers. And they wrote it that way because those are the people that do standard transactions. Doctors and hospitals and health insurers are sharing information, so they're involved in standard transactions. And then they defined what the health insurers were, and they said, you know what, we're not going to include life insurers who get your physical and have all your medical history, disability insurers, workers' compensation insurers, because they're not involved in portability. Again, having nothing to do with privacy, but having to do with portability. And my favorite carve-out in this law was, and I always use this as a test of how old my audience is, they called it the Marcus Welby exception. How many of you know what the Marcus Welby? Okay. The number of hands is getting smaller and smaller over time. But The Marcus Welby exception said basically, we want everybody to use these standardized electronic transactions, but we are not going to make Dr. Marcus Welby, the old-fashioned country doctor who would come to your house with his medical bag, we're not going to make him buy a computer. So when they started writing the rules, HHS had to write a rule because of what Congress decided that said your privacy rights as an individual depend on whether your doctor uses a computer or not. So if you go to a doctor who still bills on paper for everything, you have no rights as a patient under the HIPAA privacy rule. That, of course, makes no sense if you are thinking about privacy, but you can understand how they got there because they weren't thinking about privacy. They were thinking about administrative simplification and portability. So they had covered entities, healthcare providers, and health insurers. HHS invented something called a business associate, which is basically a service provider. They recognized that hospitals hired consultants and accountants and law firms and technology firms and things like that. And they made those business associates subject to contracts. And then fast forward a few years, the law changed to make those business associates subject to the law directly. But what that means, and it's very important to understand this both when we think about the policy and frankly as individuals and as patients, is that HIPAA is not a general medical privacy rule. It is a rule that protects certain kinds of information when it's held by certain kinds of companies in certain kinds of situations. So you have to have a covered entity involved in that process for it to be regulated by HIPAA. We're going to come back towards the end about where that really matters, but it's a big deal. So today, you need to pay attention to HIPAA, first of all, if you're an individual, but if you are in the healthcare business, you're a doctor, you're a hospital, you're a pharmacy, you're a health insurer, you're a government, you're Medicare, you're Medicaid. You have to pay attention if you are a service provider to those companies. So that's, the small circle of healthcare companies, not that small circle, but think of it as a small circle. Think of a bigger circle of the people who provide services to those companies, which again could be in any industry, if that service involves any kind of patient information. I mean, it's not the people that haul trash or supply notebooks, but anybody who does any kind of work that involves patient information, and anybody who provides services to the service providers. So it's expanding circles. It covers a lot of companies. It also covers, through the oddity of how the rules work, it covers the employee benefit plans of most companies. So I didn't ask about I assume CASE provides medical insurance to people that work here. There is a CASE Western Reserve University employee benefit plan that is subject to the HIPAA rules because it offers healthcare benefits. Most companies have no idea that that's the case. Most companies don't really know how to comply with that, but that's again part of the rules. So you need to think about it if you are any of those companies, and I can use that when I talk to industry about how important this is and how many people have to pay attention to it. We're going to come back in a few minutes to all the gaps that leaves out. So when you're thinking about how HIPAA has worked, it's had very significant overall impact. It has clearly improved overall privacy practices, mainly meaning that people are more focused on what they are doing. They're more controlled in what they are doing. I don't think most doctors, needed the HIPAA law to say that they shouldn't take medical records of their patients and, send them into the newspaper so the newspaper could write a story about it. They didn't need a law to tell them that. But again, it's more controlled, more focused, more regulated. It has also improved data security practices so that the information is more physically secure. That's become important as information has become more electronic. There still are problems today with paper records. It's astonishing how often people throw away boxes of paper records and somebody finds them. It's often a investigative team from the local TV news channel. They seem to dig through a lot of dumpsters looking for stuff. But overall security practice is also much better. I think to some extent it has also raised awareness in individuals of their privacy rights, although that's going to be a real important sticking point because I think most people, if you interview them, they will say they care a lot about their privacy rights. The line that I hear in my community of people involved in this area is that people care a lot about their privacy rights, but they'll give them up for a quarter off a Big Mac. And that seems to be how most people pay attention to this stuff. So again, there's a lot of positive things that have come out of these rules, but I think it's very important also to think about whose perspective you're considering when you think about these rules, because it may be that some people like it and some people don't. You clearly are thinking about patients, but even that becomes very tricky because there are some patients, particularly people with particularly sensitive illnesses. If you have a mental health condition, you have a substance abuse problem, you have HIV, something like that, you have very particular interests in privacy. And the people that are advocates for stronger privacy laws disproportionately come from those kinds of audiences. But if you had back surgery or you had a physical last month, I'm not sure that you care about your privacy rights in quite the same way. And when we have restrictions on what can be done with data that may create problems for people with regular conditions, it's not clear that all the patients are necessarily the same. I've been looking for years in the policy debate. We have what I view sort of as extreme, and it doesn't mean that's a bad view, but the farthest, most aggressive privacy rights advocates tend to be people from mental health, substance abuse, HIV communities. There is not an advocacy group representing patients of America. There just isn't, there's no group like that. That's not an interest group. And so that's important when you're thinking about how you evaluate these laws. Healthcare industry obviously is an important component on this. The healthcare industry hated these rules when they were written. They spent a ton of time getting into compliance with these rules. They still worry about compliance today. Now, if you told them that they could take HIPAA or they could pick what's behind curtain B, that's going to be something else, they would cling to HIPAA as strongly as they could because now they like it, now they understand some of the benefits of it. We think about the government, we think about the public at large. I mean, the patient population, I mean, everybody's a patient at some point in their lives, but that may not be the same as the public at large. Individuals in general. Then you also have to factor in other people, taxpayers. If these rules make healthcare more expensive, that's a problem. If the rules challenge things like research, that's a problem. Employers are very relevant to the situation because employers still pay for so much of the healthcare in our system. So you always have to think about who the audiences are. A couple of big questions. Does HIPAA help or hurt medical care? Again, no clear answer to this. There certainly are situations where people, mainly healthcare providers, have been reluctant to share information because of concern about whether they are violating the rules. So that could, in some circumstances, hinder care. Is enforcement too aggressive or not aggressive enough? Again, there was a real concern when these laws first went into effect that if there was too much enforcement, that people would stop sharing data that needed to be shared. So that's been a very important focus. Medical research, does HIPAA help or hurt medical research, is a very hot topic of debate. The research community strongly believes that it has hindered medical research. My personal view is that the rules are actually fine and that the people trying to do the research and the people who have to approve what's being done in the research don't actually work with the rules very well, but we'll talk a little bit about that later. Let me give you two other examples where I want you to think about how these rules work. I mentioned a few minutes ago about how many laws there are. There was I don't know if any of you remember, there was a shooting at Virginia Tech close to a decade ago where a student who'd had all kinds of problems ended up very, very particularly bad shooting at Virginia Tech. They did a sort of a study investigation after the fact, and it was crystal clear that there were a whole bunch of people surrounding Virginia Tech who knew that this kid had particular problems, and all of them were confused about what they were allowed to do because of the interplay of HIPAA, state law, federal educational law, mental health rules, a whole variety of these laws. And so crystal clear that confusion played a part in not communicating concerns about this individual. So I look at that, and you can simplistically look at that and say, well, if we had clearer, simpler laws, somebody would have done something about this. And that's probably, that piece is true. You also have to think about the corollary, which is as soon as you do that, what you're going to do is you're going to flag not only that kid, but you're going to flag 99 other kids who are never going to shoot anybody. And you're going to bring them into all of that system. And it's going to have implications for those 99 kids who today would not be brought into that system. And so that becomes part of the debate. Is that a good thing? Is that a win? Is that a loss? Is that a way we want to do it? So we have to think about those questions. The next example happened more recently. There was another shooting in Orlando, the nightclub in Orlando where there was a big shooting. And there was a ton of publicity right away after that shooting about whether the hospitals could answer questions from people who were concerned about victims or potential victims. And the hospitals very quickly took a position that they were not allowed to share information with people asking questions about individuals potentially in the hospital. Now, first of all, that wasn't actually true. There was a lot, I ended up doing a flurry of interviews on this topic because there were clearly lots of opportunities to answer questions from family, friends, and others. But do we want that to be easier or harder to answer those kinds of questions? We clearly want to make it harder for a random stranger to learn something about somebody in a hospital. But how do you make that work? How do you design a system where a hospital feels comfortable answering those questions and knows who they can answer them to? If it's mom and dad, they can answer them. How do you know it's actually mom and dad? That becomes a challenge. What if it's not mom and dad, but it's stepmom who's got a problem with that? In that particular situation, it was particularly interesting to me because you wondered, there was concerns about was it a particularly complicated one because the shooting was in a gay nightclub? And you wonder, well, if a parent, I don't think a parent would call a hospital because they weren't sure if their child was gay or not and they were trying to figure that out. I suppose somebody would jump through those hoops, but that seems a little harder. But again, that's an example of, do you want to make it easier or harder to disclose information? So a couple of places where these things are having current impacts. There's an idea of building something called health information exchanges, which are programs, centralized systems to build stables of records so that your patient records are complete, accurate, reliable, trustworthy. We're trying to save costs. We're trying to improve care. We're trying to make sure tests don't need to be repeated. It was the rare possibility in the healthcare system of a win-win, lower costs and better care. What's happened, you have that as a goal. What has happened is we've now got privacy imposed on it. And so these systems are being built all over the country where privacy rules are limiting what goes into the health information exchange. In this state, you don't have mental health records. In this state, you let people pull out their HIV or their substance abuse. In this one, it's anything. They get a choice of what goes in and what goes out. My view is as soon as you do that, you've now guaranteed that those health information exchanges will not be able to achieve the goal you set out for them. As soon as you let a patient say, some of my information isn't there, that means that they are not complete, accurate, reliable, trustworthy, and you're not going to have to repeat tests. And it's even worse than that because not only are you giving rights to that person, so if, my brother doesn't want information in his system, not only have you protected my brother, but you've affected me because nobody can rely on my records either because they don't know if I've kept something out. So that's a public policy debate where we've spent a ton of money building these health information exchanges with a goal in mind and an approach that seems to me to be clearly going to result in something that will be a failure of what we set out to accomplish. A couple other areas to think about going forward. The federal substance abuse rules I mentioned, they're trying to modernize them, not clear if that's going to work. The precision medicine initiative and the cancer moonshot coming out of the White House, lots of privacy issues there. They are building what I would call sort of a gold standard privacy and security rule. Wonderful when President Obama talks about this and he can bring people into the White House and everyone can participate for that purpose. Not going to work for some standard research project coming out of a hospital in Des Moines that's trying to do this. So I worry about those issues. Personalized medicine and then genomic and genetic data going to become a real issue here. Enforcement, I mentioned this quickly and I'll just sort of do this quickly. Again, we saw an approach that was designed to make sure people were comfortable. The government went out of its way to say we are not trying to nail people. We don't want people to shut off data flows. So we're going to teach you, we're going to educate, we're going to fix problems, etc. Now you see more enforcement. Lots of people still think there's not enough enforcement. We could debate that. The cases tend to involve real significant failures of compliance or repeated problems. They don't tend to go after, they're not going after somebody who sent a fax to the wrong address. So, but enforcement philosophy is very much part of what we see in this area. We're also going to see an issue with business associates who are the service providers. It's fine to regulate a hospital. But what about a company that is, let's say, an accounting firm that has 5% of its clients in the healthcare industry, the rest are restaurants and banks and stores and whatever else they are? Do you regulate the accounting firm who's got 5% of its work in the healthcare industry the same as you regulate a hospital? Is it fair? Is it we're going to deal with those challenges going forward. And again, the government's just starting to get up on that. I mentioned security, also a real challenge. There are real tensions in a lot of public policy goals. We want patients to be more engaged in their treatment. We want patients to have access to their information. We want there to be transparency. All of those things make data more freely available to more and more people, means security is at risk. And so we're going to have a real trade-off there. And again, I think there's a real opportunity for lawyers in this field who understand enough security. They don't have to go out and build a firewall, but they have to understand what the people doing security are really doing. All right, so let me spend the next few minutes on one of the big issues that we're seeing and what I think is the most interesting public policy debate that's going on in this area today. As I said earlier, we started off with a Hipaa rule that is driven by covered entities, doctors, hospitals, health insurers. There was a lot of logic to that, driven by the history of the statute. It's also, frankly, where most of the healthcare information was in 1996 and 2000. What we have seen over the past 10 or 15 years is an explosion of data about people's health outside of those more traditional avenues. We have websites by the thousands that gather and distribute healthcare information. Companies like WebMD collect all kinds of stuff. If you go to WebMD and you start searching for information on it, they're building all kinds of information about your interests and your healthcare information. Think of all the patient support groups and community support groups and local, Fight Cancer Group or Fight this, all of those things are collecting that information. Those have been going on for a while. Last few years, we've seen the enormous expansion of mobile applications that are collecting healthcare information. If you go to the iTunes store and you download a mobile app to track your blood pressure or whatever, there's no doctor, there's no hospital involved in that. That information is entirely unregulated by the Hipaa rules. Most recently, we've seen the Wearables Explosion. Anybody have their Fitbit or their Apple Watch on or anything like that? Again, no doctor's giving that to you. That's not through the doctor. That's because you went out and bought a Fitbit. So we've seen this explosion in data that is about your health that is not regulated because the Hipaa law doesn't regulate healthcare data. It regulates health information when it's held by certain people in certain contexts. At the same time, we've seen companies within the healthcare industry using an enormous variety of non-healthcare data to do their jobs. They're bringing more and more non-health information into the healthcare system. Let me give you a couple of examples. Recent story from Bloomberg News. You may soon get a call from your doctor if you've let your gym membership lapse, made a habit of picking up candy bars at the checkout counter, or begin shopping at plus-size stores. Most people do not think of their pant size as healthcare information. New York Times, health plan prediction models using consumer data from data brokers, including income, marital status, and number of cars to predict emergency room use and urgent care. Income, number of cars, marital status, maybe that's mental health information, but we don't think of that as healthcare information, yet people in the healthcare industry are using that. Employers are quietly using big data to track employee pregnancies. So we've got two related developments. We've got the explosion of non-Hipaa healthcare data, and we've got a similar explosion of healthcare companies using other kinds of data, income, marital status, number of cars, pant size, in connection with healthcare purposes. So the question is, what are we going to do about that? There is a building debate that basically says this is a problem. And I don't want to get too technical for those of you who aren't lawyers, but there's a building desire to do something about this. That's very technical. Again, do something. There is no consensus whatsoever on what that something is. And so I work in Washington. I work in a mixture of law and regulation and policy. This is a perfect Washington storm. There are people giving speeches and writing articles and having hearings and having, seminars and making a lot of noise about this stuff and posturing themselves for where this is going to go. But it's a building debate, and I think that debate is not going to go away. There's just too much data being generated in too many different places that's being used for too many complicated, confusing, and potentially harmful purposes. So I have come up with 3 alternatives. There are lots of others, but these are conceptually how you look at this problem and how you solve it. And I want you to think about this in the context of the other points we've talked about. Whose perspective are we looking at? What are we trying to accomplish? How are we going to balance all these different goals? So 3 main options are: 1, do something specific about this non-HIPAA healthcare information. The healthcare information that's collected by your wearable, that's collected on the mobile app, that's collected on these community health sites. That would be the simplest option, probably. Second option is to say, well, wait a minute, if we do that, we still have 2 rules. We have HIPAA and we have the other rule. So maybe what we should do is have a single new law that covers all healthcare information. Get rid of the HIPAA approach, forget portability, forget covered entities, let's focus on the information. That's an option that lots of people in the healthcare industry aren't thinking about, because if they were thinking about this, they'd say, we have to go out, because that's a real possibility. We like HIPAA. We have to go figure out how to make this law, if it's a new healthcare law, actually look like the principles of HIPAA. So the hospitals, I think today, think we don't have a dog in this fight, but they really have a very big dog in this fight, because if this law comes out and it's not HIPAA, that's a problem. So first option is narrow. Second option would be all healthcare information. But then you think about if your pant size and your income and your marital status and your number of cars is used by the healthcare industry to evaluate healthcare activity, how do we define what healthcare data is? And so that leads, logically at least, to the next alternative, which is pass a general privacy law affecting personal information. Now, that kind of law exists today in the European Union. It exists in a lot of other countries. We do not have that here. We have a sector-specific laws or practice-specific laws here. But those seem to me to be the options. And again, I could see a final exam on a law school class being, give me the pros and cons for all kinds of audiences for each of those approaches. And that's what the policymakers are going to have to do. They're going to have to figure out, there's a recognition that there's a problem that needs a solution, no consensus on what that solution is. These are some of the options, and at least in the big picture, they cover the range. I mean, I guess the fourth option is do nothing. You could probably come up with sub-points on this. But how we resolve this is going to have an enormous impact on the next generation of what's going on in the healthcare industry. So let me wrap this up. Dramatic implications across the healthcare industry from the choices we make on privacy. It affects all of the programs you can think of over the last 15 years in building the healthcare industry. It can drive the future of healthcare in a variety of different directions. There's an interest in having patients more engaged and making things more personalized. That has an impact on the privacy rules and how we do that. And I think you cannot design or evaluate any kind of healthcare program without incorporating and addressing these privacy ideas. And you're better off doing it before you start than having to deal with it later. I also think the tensions we have are growing, and so the conflicts and the battles we're going to see are going to be trickier. That just said, so we're going to spend the next at least 5 years, I think, fighting out some of these battles on particularly this non-HIPAA healthcare data. So lots of interesting things in this area, great opportunities if you are a law student in this area. If you are not a law student but you work in this field, this stuff affects you. There is nothing that you are doing in the healthcare industry, and that means directly in the healthcare industry, all the people that use information from the industry, all the people who are service providers in the industry, patients at large, everybody is affected by the choices that we're going to make on this. So let me stop there, and we will have some time for questions on anything I've talked about today. Thank you.
We have about 10 minutes for questions, and since we have a lot of people in the room, please try to keep them brief.
Check, 1, 2, check, check. So the question is, have I thought about Watson and artificial intelligence and how that plays into it? So that's a perfect example of the sort of aggregation of inside Hipaa data and outside Hipaa data. So Watson is, for those of you who don't know, is an IBM artificial intelligence program that's basically, I'm going to, this is going to be a simplistic way to think about it, but it's supercomputer power applied to big data. And it's coming out with, they have all kinds of things that are not healthcare, but Watson's got a big healthcare focus. And so they're pulling information in from anything they can. Sometimes that means HIPAA, sometimes that means not HIPAA, sometimes that means not health, sometimes that means whatever, and they're trying to come up with analytics for those kinds of issues. It's a huge concern, not just in healthcare, but in big data generally. There are some principles, one of the privacy protection principles is only collect what you need and only keep it for as long as you need it for that purpose. Watson and other big data is, let's collect everything, we have no idea what we're going to do with it, we need it all now. So you've got security risk, you've got analytic risk, there's a lot of concern about what's being done as a result of big data, what kinds of conclusions are being drawn about people. There are concerns that big data is going to, in fact, there's a quote from the White House on a big report on big data that says there's the risk that big data will eviscerate a wide variety of civil rights concerns in healthcare and poverty, just a big variety of concerns. At the same time, this is where the tension comes in. There are enormous outcomes that are being generated by programs like that. And there's nothing unique. Watson may be more sophisticated than some of the others, but there are all kinds of people doing Watson-esque things. And they're all, again, this law that I'm talking about is going to affect every single one of those data analytics companies. Yes, sir. Sure. Yeah. Well, let me start with the second part. So the Pandora's box piece. There is some truth to that. There was a famous quote that goes back 15 years ago from a CEO of, I'm going to blank on the name of the company. My friend was the privacy officer there at the time, so this became a huge deal. Sun Microsystems. Their chairman said, "You already have zero privacy. Get over it." And I said, for my friend who was the privacy officer there, that was a constant problem. But that's a consideration of how you regulate these issues. Now, let me go back to that health information exchange example I was using, where right now everyone's coming up with their own system and people get to pick and choose. And my solution to that is a little bit of opting out, which is you're either in or you're out. And if you're out of the health information exchange, that's okay. That means you're not going to get these benefits, but you opting out doesn't affect everyone else's records. If you opt out 12%, all of a sudden we don't know whether everyone else's records are reliable. If you do it in or out, you've either got everything or you've got nothing, and I know what to do as a result of that. So there's some of that discussion. Now, and the damages question is an interesting one. Everybody gets, all companies all over industry, not just healthcare, are having security breaches. How many of you have gotten a notice in the mail from some company saying your information was, frankly, the people that aren't raising your hands aren't reading your mail because so those are happening all over the country. And one of the things we're seeing in the legal system, I actually was on a panel on this last week, is the day the press release comes out announcing a security breach, there are 5 class action lawyers filing a class action case saying all these injuries. There is, you could build an entire law school class on the jurisprudence about those cases right now. There's an explosion of those cases. I'll do a simplistic summary, which is, for the most part, the courts have said in the class action settings, unless you can allege very specific damages, those cases are getting dismissed. And they're getting dismissed at the front end as failure to state a claim, no cause of action. So you don't even have to go through discovery. I describe that as a brick wall of cases being built up over about 15 years. But there's a crack in that brick and a hole in that brick, and that brick's missing, and the plaintiff's bar keeps poking at it. And at some point, we may see the wall come tumbling down. We aren't there yet. And so, the cases that I've seen that justify some damages have been individual situations where a particular person has been harmed in a particular way. If you have medical records that are stolen by a hacker, I don't know what you do about that. It's also interesting from the regulatory requirement, a hospital has to send you a notice letter saying that your records were stolen by a hacker. And in that notice letter, they have to tell you steps you should take to avoid future harm. I have no idea what to tell somebody. The record about your back surgery was stolen by a hacker. What do you do about that? I mean, if somebody steals your credit card or your social security number, you get a credit report, you put a credit, there's things you can do to prevent identity theft in the financial context. I don't know what you do about your medical records, even if it's sensitive medical records. I mean, I guess it's a heads up that something bad might happen to you at some point in the future that might cause, but I don't know what you do about it. So it's a real challenge. But so far, the litigation, again, lots and lots and lots and lots of cases being filed. Probably all read about the Yahoo breach notice. Not a healthcare thing, obviously, but there's at least 5 class actions that have been filed in that case, and that's, we have no idea what's going to happen with that information. So, there's I'm not sure anybody's trying to make it easier to collect damages because most of these situations there isn't any. There's no demand. Most times something happens, but nothing then further happens after the data has been taken. There are some statutes where there are statutory damages, and that's a current fight. Is what do you have to prove to even get statutory damages? So, other questions, comments? I'll come back to you, but yeah, go ahead. No, you. Sure. So I talked about the state laws and how complicated state laws are with the federal law. That's the same problem that comes out internationally. And so the EU came up with the first real comprehensive set of privacy laws back in the mid 90s. And they're in the process of putting out a new set of rules that's going to go into effect in 2018. So if you are a company in the EU, you have very strict privacy protections that apply to all information in all contexts. So it's not a healthcare law and a financial services law. It applies to everybody all the time. And it applies, the impact on US companies is that the EU laws impose restrictions on how data can leave the EU to come to the United States. And it can only go to countries that have, I'm blanking on the exact phrase, but it's basically appropriate privacy protections, and the EU does not view the United States as having appropriate privacy protections. So that in 1995 or so created a huge diplomatic problem that resulted in a negotiated arrangement with the EU where companies in the US could jump through a bunch of hoops and get data here. That program was blown up about 2 years ago following the Snowden revelations. The EU basically said, we're not doing that anymore. And so we're in the middle of a new program that's being built. But that just gets data from the EU to the US. It doesn't say anything about how we get data from Singapore or China or India or how data goes back and forth. And it's an enormous problem. One of the places in the healthcare industry it's impacting is clearly medical research that's on a broader scale outside of this country. Very, very hard to do that. Some companies just have stopped doing global healthcare research. They may go into India and do research in India, but it's very hard to do that. So, you could take my point about having a single law that we could all understand and try to apply that at the global setting. We're just not there yet. And in fact, right now it's becoming more fragmented rather than less fragmented. Do you have another question? Yeah. Yeah. The, Yeah, I mean, here's one place that came up. There's a concept that I haven't really talked about called de-identifying information, which is taking your medical record and putting it through a bunch of steps to make it no longer connected to you. And there's a process in the Hipaa rules to do that, and that's a big part of how data is used in a lot of these big data analytics pieces. There were a number of lawsuits filed the last maybe 3 or 4 years ago where patients basically sued some of the big pharmacy chains who do a lot of this. They have a ton of data and they de-identify it. And they essentially said, well, first of all, they said you didn't de-identify it right, so you violated the rules, but put that aside. They then said, you're making money off of our data even though it's de-identified. So even if there's no privacy risk when somebody buys our data, we want our cut. We want our share. Well, if you went to Walgreens or Rite Aid or CVS, you were in that class. So those cases did not succeed for the time being. I tell my clients I think those cases are coming back. I'm not sure how that's going to work. And we haven't, there's not a lot of ammunition there at this point for people saying that. Now, there are situations where it's, for example, under the Hipaa rules, basically the Hipaa rules have a principle. There's a set of things you're allowed to do with data. Everything else you can do only if the patient says yes. So if companies want you to say yes, they can clearly pay you to say yes. There's no question about that. So we may see some of that in some situations, and people get paid to participate in research studies and things like that. But we haven't really seen paying me for my data to be put into a big data pool. And I'm not sure. I think we're a bit of ways away from there. Thank you very much.
So we have a small token of our appreciation. Thank you so much. This was terrific. And for students, if you want career advice, it's well worth having room A64, please.